and in the bill.
My Lords, apologies that I didn't get to speak at the second reading. I misread the order paper and thought the day started with questions. However, I listened to all the speeches and I certainly got a sense of the mood of the House. I note, perhaps, that that mood is at odds with the mood beyond the House, however. And in a previous point that was made about unanimity, unanimity can be a cause for celebration, but it can be also an echo chamber. However, definitely, undoubtedly, on this bill, there are problems, specific problems, that I think need to be tackled in this scrutiny in the House of Lords. They need to be tackled if the government is to fulfil its promise to the electorate to get to grips with controlling the borders of our country. Controls which people feel are being flaunted by an inability to stop the small boats. So if this House can ensure that this bill works, all to the good. One aspect of that is that we are going to need some clarity about what and who will be affected by this bill and why. And in that context, I'm very sympathetic to Amendment 1 in the name of the noble Lord, Lord Hope of Craighead, because I think it's a valiant attempt to provide a definition of illegal and unlawful migration, and it could be helpful in improving the public debate on the issue, which often gets in a muddle on this. So often, when the issue of channel crossings arises, and a popular reaction to them is that these are illegal crossings, and they say that, they are scolded that they are not illegal crossings and that they ought to know the law better. And so if there's a way of clarifying what the law is, all to the better. Because that can be frustrating, because for so many people, they feel that they're being gaslit on the question of the law. And maybe that's why Amendment 1 will give us some clarity. However, it's also one of the reasons why achieving this clarity probably can't just be done via definitions. Because there is an impression, certainly outside of this House, and I'm sure that people will put me right, the whole swathes of lawyers and NGOs with legal advisors provide those in the boats with legal get-out clauses and exemptions such that, frankly, it looks like an organised system to game the system. And that's not coming from the people in the boats, but from the legal minds who are sympathetic to their cause. I can completely understand why anyone would want to live in the UK from many of the countries they're travelling from to improve their circumstances. But by any reasonable definition, many of the people in the boats, or some of the people in the boats, or how many people in the boats, are not refugees in need of asylum, even if they are desperate to improve their standards of living, to get away from countries they don't want to live in. I can understand that they can be encouraged to follow a script, to find a way to stay in this country, and you can empathise with the desire to do that. But we can also note that, frankly, that tests the bounds of legality. And in the process, there is a serious danger of discrediting what, for example, we mean by modern slavery, which I think is being exploited, what we mean by legitimate asylum status. I also wondered what the noble Lord, Lord Best, would make of the legal rows that happen within the legal and judicial community about definitions, what words mean. It's not as though if you put it down, it's always clear. We keep hearing about eminent lawyers and fine minds and so on. There are, believe it or not, amongst those fine minds, eminent lawyers who disagree with each other. So I was involved in listening to a very lively row between two fine, eminent legal minds about the interpretation of Article 31 of the Refugee Convention, which one read it to say that refugees must come directly from a place of danger, i.e. not France, present themselves immediately and show good cause for their illegal entry and so on. Then the other person explained that actually coming directly amongst some judges would mean that you could come through other countries. Anyway, the row went on, and I'm not saying I understood it all. But it's not as though every time the great legal minds give us a sense of legal certainty. And all this legal confusion can and does lead to a cynicism that people are illegally breaching border controls and that illegality is not being tackled. And I think there's a danger here that this can discredit the rule of law itself. And I certainly agreed with the Shadow Immigration Minister, Stephen Kinnock, who has talked about the whole process being slowed down and clogged up by legal challenges and what the problems that causes. So, in a way, my question to the Lord Hope is, even if we establish a clear legal definition, how do we tackle the various loopholes, spurious claims that can create incentives for illegality that we can't deny happen? People being told that maybe, or adults claiming their children when they're adults in order to stay, destroying papers and proof of country of origin and so on. Or we just to say that never happens. This fudging of legality and illegality, I think, has made it inevitable that debate has now moved on to lots of concerns about legal migration and numbers and so on. And I think somehow the slowness of tackling illegal questions has actually created a far more hostile environment for discussing migration, full stop, whether economic or in terms of asylum, and I really regret that. A lot of this is based on what is seen as untrustworthy politicians refusing to keep their promises. And so I wanted to look at that problem as potentially one that's created by Amendments 2 and 4. Amendment 2 aims to disapply Section 3 of the Human Rights Act for this bill, but actually that's one part of the bill that I agree with, because it at least tries to ensure that what Parliament intends to happen actually happens, and not allow the EHRC to be used as a barrier or an excuse to that endeavour. Amendment 4 comprises a list, essentially, of what is described as key international obligations, and they have been read out, but I think it's important to acknowledge that the 1950 European Convention for the Protection of Human Rights, Fundamental Freedoms, the 51 UN Convention on the Status of Refugees, the 61 Convention on the Reduction of Statelessness, and the Convention on the Rights of the Child in 1989, and the Council of Europe Convention on Action Against Trafficking in 2005. I want to just state here and now, I am not arguing against all of those acts, right? That's fine, right? There's some arguments one might have, but that's not my point. The reason why I've got a problem is the way that this important list is being potentially used or deployed to neuter this bill. At second reading, concern was expressed that the bill rips up long-standing commitments to international law, and we've heard that today. But my concern is, how do we avoid ripping up Parliament's long-standing commitment to UK democracy if international treaties become a barrier to acting at the behest of the electorate, which is what Parliament's meant to do? What happens if those international treaties render bills passed by the elected House, the House of Commons, unworkable when we have them here? I think that it is true that the UK's international reputation matters, of course. But I also think that the parliamentary reputation matters at home as well to UK citizens. And I don't think we should forget the widespread, huge frustration when the public are told, you can't do that. Sorry.
It's really suggesting that this House, forgive me, this country should depart from treaty obligations, really without much of a qualm.
Having no qualms is something that I would never do, but I am also suggesting that having qualms, or using those qualms to undermine what actually the British public would like to do, is something that other people should have qualms about. Because I think that people, I just wanted to state that I think that people are tearing their hair out outside of here, being told you can't do that, you may have voted for that, that can't happen. And when international treaties are used in that instrumental way, which is the way I think they are being used, I think that's difficult. I just want to just ask you, finally, if I can ask my noble lords to put aside the specifics of this bill just for one moment. And I know people are very emotional about this bill. But what if, on another topic, the UK government, perhaps another government, not this one, that maybe more people in this House might be sympathetic to. Just imagine if such a worthy government, with a popular mandate, tried to bring in a radical, novel, innovative law, for example, enhancing workers' rights or improving women's reproductive rights or whatever, things that I would support. Imagine if that government tried to bring that in and it got to the Lords and they were told you can't do that because there's all sorts of international treaty clauses that prohibit you doing it. Imagine your frustration. Would you break your promise to the electorate in that instance? So I just want us to acknowledge that asking the government to break a promise on the small boats.
Order.
I wonder if the noble lady would like to remind the committee which limb of the Constitution takes responsibility for negotiating and revising treaties on the world stage. Is it the judiciary? Are they the wicked people that run off committing us to all these international obligations? Is it parliamentarians who go and negotiate these instruments that she's finding instrumental? Or is it the government who negotiates, renegotiates, and in some cases even walks out of international obligations?
My Lords, I don't think there's evil people involved in this, and I haven't gone down the it's moral, immoral route. I'm concerned, genuinely concerned, with ensuring that the electorate and citizens of this country do not feel that the parliamentary discussion uses international treaties as an excuse to not do what they anticipate that Parliament was asked to do. I'm just saying, if, for example, it could be the abolition of the vagrancy. There's a lot of promises being broken recently, let's be honest. I've heard excuses made for why we haven't yet abolished the Vagrancy Act. I've heard excuses for why we can no longer get rid of tuition fees. I've heard excuses for why leasehold won't be abolished.
The noble Baroness will recall that we had a referendum to leave the European Union. Many of us opposed that, but it was a clear will of the democracy of this country that we left. So surely these international obligations that we are saying that we are bound by, if the demos, the people of Britain, feel that they wish not to be bound by them, that is a perfectly legitimate thing, and we have to find a way of carrying the wishes of the people into legislation, not use the international agreements to say that the wishes of the people must be ignored.
I am coming to an end. I understand your point. I am trying to, or endeavouring to explain, that I think that those international agreements are being used in a particular political way on this issue. I have suggested that breaching promises to the British electorate, and I was trying to give some examples across party lines so that nobody would think I was having a go at any one, are leading to a cynicism and a bitterness in the electorate, and a low turnout at the local elections was an indication of the fact that many people feel politically homeless. I do not support necessarily this bill. I want it to be scrutinised by this House. But I felt that the amendments that I was referring to were almost avoiding scrutiny by simply ring-fencing off the whole nature of the bill and saying you can't do that because of international treaties. That seems to me to render us even trying to scrutinise the bill a waste of time and will lead to even more cynicism about the lack of democracy. That's my point. And it's got nothing, as it happens in this instance, about Brexit or the EU, although the desire to control one's borders and one's laws were undoubtedly part of that. But I wasn't making that point in this instance.